Hereby, I open this academic ceremony in which Francesca Mazzi will defend the academic thesis Patentability of Artificial Intelligence-Generated Inventions, a case study on pharma. May I invite you to present the summary of your study and the conclusions of your thesis.
Thank you. Highly esteemed Prorector, highly esteemed members of the Corona, dear supervisors, family and friends present and at home, good afternoon. It is with great honor that I present you my doctoral thesis titled The Patentability of AI-generated Inventions, a case study on pharma. My research was conducted within European Innovation Society project framework under the supervision of Professor Noam Shentov from Queen Mary University of London, Professor Mer Pugac and Professor Dick van Engelen from Maastricht University. In this presentation, I will first set the scene by illustrating the background of my research, the methodology and the case study. Afterwards, I will focus on findings and conclusions. So let's start with the background of the thesis. There are many definitions of artificial intelligence, and here I provided one selected by Russell and Norvig, namely the designing and building of intelligent agents that receive percepts from the environment and take actions that affect the environment. The term artificial intelligence is rooted in the definition coined by John McCarthy in 1956, and since then there have been periods of discouragement in the field as well as period of enthusiasm. But recently this research has become important because contextualized within the advent of the Fourth Industrial Revolution and the proliferation of data, artificial intelligence allowed for the progressive automation of some activities that can be considered inventive, so activities that lead to patentable outcomes. For example, artificial intelligence allowed for the creation of smart labs, and when we talk about artificial intelligence-generated inventions, we refer to inventions that are not only the result of one technology, but are the result of multiple technologies that work interconnectedly and in an integrated manner. For example, hardware such as smart sensors and software such as artificial intelligence indeed. This chart gives an idea of the rapid evolution in patent application of core AI from 2008 to 2018, and this only gives an idea of how rapid it has evolved in recent years. Consider that AI patent only represent a part of the R&D in patent. Part of artificial intelligence is also kept as a trade secret. To provide an overview of the extent to which technologies are involved now and can be involved in the future, one has to consider that artificial intelligence is of today, as of today, 2023, is not the same that it was in 2017 when I started my research. Therefore, I identified two scenarios, Ingenious Machine 1.0 and Ingenious Machine 2.0, that describe, on the one hand, the type of artificial intelligence as it is today and the extent to which activities can be automated today, and the hypothetical scenario where artificial intelligence is able to perform entire inventive stages alone. In terms of methodology, I obviously employed different types of methodology for this research. So part of it was traditional doctrinal research with reference to statutory provisions of national and international laws, as well as case law and different documents from administrative bodies. And on the other hand, I also employed empirical research to build the case study, which I will explain in the next slide. This was employed to answer different types of research questions: descriptive, explanatory, comparative, and normative. There is a macro research question of the topic, which is, are AI-generated inventions compatible with the patent system? And in order to answer these macro research questions, I unpacked the research question in different micro research questions, analyzing specific requirements. So, for example, the micro-research questions concern whether AI-generated inventions are compatible with inventive step and with the requirement to name an inventor in a patent application, as well as with sufficiency of disclosure and if they are compatible with patent law justifications in general. Now, in terms of the case study, as I mentioned, I employed empirical research considering the high use of artificial intelligence for the pharmaceutical sector, for example, for drug repurposing, drug discovery, and for the design space for new compounds. In order to perform this case study, I had the chance to structure semi-structured interviews, and I had the chance to interview the relevant stakeholders identified through two partner organizations, the European Federation of Pharmaceutical Industries and Associations, and Ovione, which is pharmaceutical companies. Through their partnership, I was able to be in contact with people working in different departments, from the IP departments to the product development departments, and to define two types of case studies, one concerning a product patent and one concerning a process patent. And in both cases, I used this for the section on inventorship, evaluating the contributions that entitle the inventors to be named as such in patent application. Now, moving to finding, in terms of inventive step, through the historical analysis of the requirement and the rationale of the requirement, it became obvious that inventive step plays a crucial role in the patent system, as it distinguishes between inventions that are worth patent protection and those that are not worth it. That being said, there have been throughout the years different traditions, a nominalist tradition and a realist tradition in assessing inventiveness. A nominalist tradition focuses more on the figure of the inventor, whereas a realist tradition focuses more on the attribute of the invention itself. It has become obvious in the recent years that across different jurisdictions, the realist tradition is the one that is prevalent, but at the same time, inventive step is assessed through a nominalist lens, because the person skilled in the art is a quintessentially human parameter. So this generate the doubt in terms of compatibility with AI-generated inventions, the construction of the person skilled in the art. However, it has also been evaluated another type of solution, which is to use artificial intelligence skilled in the art, and it has been noted that this would not work in the case of human-generated inventions. So it has been considered the fact that continuing to construct the person skilled in the art as it has been doing so far, so including the technologies that are part of the state of the art, would allow to maintain a fair bargain, because most likely artificial intelligence and data will not be in the public domain, so they will not be diffused to the extent to which everything becomes obvious. Now, for what concerns inventorship, we in the thesis have two aspects were analyzed. The first one concerns the different jurisdictional approaches, and the second one concerns the different degrees of artificial intelligence involvement in inventive activities. The jurisdictional differences are relevant because inventorship is not harmonized at international level. The definition of inventor is left to national discretion, and the recent artificial inventor project, the Dabus case, has shown that different approaches might become difficult in case courts don't harmonize internationally. However, most of the jurisdictions have rejected the Dabus application that name AI as inventor, and only in South Africa, where there is no ex-ante examination, the patent was accepted. For what concern the different degrees of involvement of AI in inventive activities, it must be underlined here that according to the two scenarios that I have defined in the thesis, in the ingenious machine 1.0 still have a predominant human role. So even if AI can automate part of the inventive activities, it is still possible to find a human in the loop and then name him as inventor. And in the hypothesis of ingenious machine 2.0, it has been said that according to, for example, the jurisdiction of the United States, the patent in theory could be invalidated because of wrongly named inventor. But at the same time, should that be the case, it has been also underlined that different considerations that are outside patent law concerning the legal status of artificial intelligence should be considered. And therefore, a solution that comes merely from patent law would not be recommendable. In terms of the sufficiency of disclosure as a requirement, it has been analyzed in relation to artificial intelligence and in relation to specific cases where artificial intelligence is part of the inventive process and might be part of the result product as well. It has been underlined that the disclosure requirement is particularly important as it is the quid pro quo of society between society and inventors. So through the claim, the inventor gives back to society the possibility for a skilled person to be enabled to replicate the invention. Therefore, this requirement is more focused on the characteristic of the invention itself, rather than on the way it is produced, rather than how the invention is produced. Therefore, it is most likely that in both cases of ingenious machine 1.0 and 2.0, despite of the fact that AI might be involved, a human person might probably involved in the writing of patent application and even only in the acknowledgement of the value of the invention, and therefore it should not be particularly problematic. One problem that has been discussed in the literature concerns the fact that disclosure requirement as it is now might incentivize the disclosure of downstream innovation and not of the upstream innovation, which might create challenges in terms of concentration of knowledge. However, this is something that should be addressed from a competition law perspective rather than from a patent law perspective. Finally, the chapter on justification theories of patent law and intellectual property law highlighted different theories and different justifications underlying the system. We have identified the Lockean and Hegelian theories as those theories that focus more on personhood, whereas utilitarian theory, incentive theory, and reward theory focus more on the invention itself, on the product itself, on the progress itself. Therefore, in terms of ingenious machine 1.0, there wouldn't be any challenge with any of the theories, because the human in the loop is still present. So even from a personhood perspective, it would not be a problem. However, with ingenious machine 2.0, in theory, the personhood theories would not be compatible on a prima facie analysis. However, at the same time, the Lockean and Hegelian theories are more used to justify copyright than patent. And also, from an abstract perspective, it is also possible to argue that the act of creating AI, because AI is not in nature, is still an act of putting the ingenuity in the human ingenuity, and to facilitate progress and innovation. Therefore, it is argued in the thesis that also in the case of ingenious machine 2.0, it would be desirable from a societal perspective to have the patent system, so that incentives in AI would still be present, and people could have, and the companies would have a prospect of recovering their innovation costs. As a final point, I would like to sum up the findings and state that in the thesis I suggest that we continue to build the person skilled in the art according to the state-of-the-art technological level, and this would facilitate the maintenance of the optimal bar for inventiveness. I would still recommend to monitor the level of diffusion of AI and data in the public domain to evaluate the need for eventual adjustment in relation to inventive step. And for what concerns inventorship, one of the options that have been suggested by some scholars was to eliminate the requirements, which I would, after having analyzed the function and the rationale of the requirement, I would not recommend, because a human-generated invention would still happen, and it would be still important to have it. And then finally, whether or not AI will be able to be named as the sole inventor will probably depend on other factors, such as whether it will have a legal status or not in the future. Thank you very much, and I now pass the word to the prorector. Thank you.
Thank you for your presentation. The opposition will be opened by Professor Anselm Kamperman-Sanders. He is a professor of intellectual property law at the Faculty of Law of Maastricht University, and has acted as the chairperson of the assessment committee.
Thank you very much, Mr. Prorector. Dear Miss Candidate, congratulations on finishing your PhD. At least present your manuscript here for the defense today. It has been a joyful read, but of course also a read that generates some questions. So it will not come as a surprise that I have some for you. Now, first of all, let us turn to the EU's AI Act, which was debated in the European Parliament, and it basically outlines a risk-based approach to medical health, anything to do with medicine, which will in turn lead to a high level of ethical and human oversight, thus reducing, in the context of your research, the autonomy with which AI can be tasked. So possibly we are stuck with indigenous machines 1.0 only. How will the EU AI Act then have an effect on your findings in relation to the patentability of AI-generated inventions, especially in relation to the due diligence and sufficiency of disclosure that will be required in the specific sector of the research that you have undertaken in the medical, in the pharma industry? After all, that may mean that in respect of the use of AI, black boxing will have to be a thing of the past. To be a bit more specific, and this also goes to your comment that, well, competition laws should deal with a lot of the problems that is caused here. Even if we can use ingenious machines 2.0, where enablement, after all, leads to machines teaching other machines rather than humans, because the human is out of the loop and cannot understand what the AI is doing anyway, shouldn't there be a task for patent registries to become an open source repository containing all data, algorithms, in and by itself? For otherwise, there will be no justification for the maintenance of the patent system as a social contract in the first place. I would like to hear your views on this.
Highly esteemed opponent, thank you for your question. It is interesting opposition to consider the AI Act in relation to the thesis, as this thesis was started before the AI Act was conceived, but during the final stage of the PhD, the AI Act became out there. There was the release of the draft. The risk-based approach gives indeed some good hope in relation to safety and in relation to the way AI will be used when it comes to healthcare. As you mentioned, the risk-based approach will be particularly strict in the healthcare sector, and in this sense, this will probably lead to a situation where some of the stages of inventive activities in relation to pharma will have to be double-checked by a human, and we'll have to have a human intervention in it. It is surely a different approach compared to the one in the United States, and I think the reason why the European Commission decided to adopt this approach is to create a sandbox and to have a safe creation of and development of AI. So putting the human at the center of the innovation. And in this sense, it will give us the possibility to develop artificial intelligence in a safe way. And probably this will limit the scenario that I have presented of Ingenious Machine 2.0 to an extent. However, in terms of due diligence and sufficiency of disclosure that you mentioned, this will also create possibly some situations where what could have been a problem without the AI Act will be solved with the AI Act. For example, it is possible that registries for artificial intelligence, I mean, there have been already the suggestion of creating registries of that types, and probably the fact that training data will have to be deposited in a maybe not open access way, but still in a controlled environment, will create additional safety and will create a situation where there will be a protection of intellectual property generated invention and artificial intelligence generated invention, but not to the extent to which it is artificial intelligence autonomously generated inventions. There will always be probably a human in the loop for the time being of what is foreseeable. I hope this answers your question.
Thank you for your reply.
Thank you. The opposition will be continued by Dr. Enrico Bonadio. Dr. Bonadio is a reader in intellectual property law at the City University of London and also a member of the assessment committee.
Thank you. Thanks so much for the presentation. I really enjoyed reading the thesis and listening to your presentation. Very clear, very well structured. I have also a specific question on novelty, on the novelty requirement. You mentioned in a part of the thesis at the beginning that you mentioned this company called Cloem, right? It's a French company, as far as I understand, which what they do basically is to use AI, as you said, as you wrote in the dissertation. They use AI to combine available data and undermine or trying to jeopardize the novelty of potential combination of data. So what they do is to, mining data and publish them in websites or so on and so forth. So these AI-generated claims are created to basically saturate the technical space with probably the aim of, preventing competitors from obtaining improvement patents and in the same field, in the same area, right? So you mentioned this issue. However, I would like to know your opinion on on this. I mean, not all information published, for example, online, should be considered capable of destroying the novelty, right? There is a methodology of, of assessing such data. Not everything which is put there is enabling disclosure, right? So I wonder how you would, provide a solution to this. How would you distinguish between data which is capable of destroying novelty from data which is not capable of destroying novelty?
Highly esteemed opponent, thank you for your question. I believe that I didn't touch upon novelty in my thesis because I didn't think it was relevant for the patentability of AI-generated inventions. However, I acknowledge that it might be a problem from another perspective. One of the conferences that I attended during the research, a very interesting discussion was made about using AI to detect prior art that is relevant and differentiate between data that is actually relevant for destroying prior art from data that is actually not enabling any kind of invention. However, using AI for this purpose, I think it was still at a very infancy level, so not yet developed. But because the prior art assessment is based on whatever is available in the world, it might be relevant to try to find a way to differentiate between what is actually relevant prior art and not relevant prior art. And maybe using AI could be one of the solutions to that.
Mm-hmm. And probably take a decision on a case-by-case basis, basically, to see whether such disclosures are really enabling such data, really destroying novelty or not, right?
Yes.
Okay, thanks. I'm satisfied with that.
Thank you.
Yes.
Thank you.
Oh, sorry.
The opposition will be continued by Dr. Gaetano Dimita. Dr. Dimita is a senior lecturer in intellectual property law at Queen Mary's University of London and also a member of the assessment committee.
Thank you very much, and thank you for your presentation, and congratulations again for finishing your thesis, and it was so nice to see it print out in a book form. I do have a number of questions, but my main one, I would like to ask the candidate if she could expand on her reflection on justification. Because firstly, I really appreciate seeing them there at the beginning in order to determine the desirability of a reinterpretation or accessibility to the patent system for AI-generated invention. But my question is quite specific. Firstly, I noticed that you're quite pro-patents in your assessing the link between the patented invention and innovation, and whether or not you would like to expand and reflect on the counter-argument on the accessibility of the patent regime for this kind of invention. And then in the long run, since I really appreciate the fact that you're always constantly trying to move into 2.0, because kind of an assumption that 1.0 is already here, we are dealing with it, we are ready for it. But in the future, whether or not you would think that probably this justification theory should be addressed in a different way, and whether or not you think that this different approach to justification should change depending on the industry we're dealing with. Because I appreciate your thesis on pharma, but sometimes justification theory works better in pharma than in other industries.
Highly esteemed opponent, thank you for your question. So when I talk about artificial intelligence generated inventions, and I refer to ingenious machine 1.0 and 2.0, I make a distinction based on the fact that the human in the loop in 1.0 is still there, and is still necessary to come up with the invention. So in this case, that's why I say in this case, I don't see a particular challenge for the theories, for the justification theories. I see it, artificial intelligence, as a tool that is actually available to the person or to the group of research in a lab. So as it has happened in the past when new technologies arrived and were available, for example, the person skilled in the art was constructed according to what was available there. So in this case, this is why looking at the justification theories and looking at this kind of technology, I don't see a particular challenge. However, I must admit it is more difficult to justify it in the case of Ingenious Machine 2.0. First of all, because the patent system was conceived in a situation where the human ingenuity was the object of the incentive, and the system used to work in order to address and to incentivize humans to invent and not artificial intelligence. However, at the same time, except for the personhood theories, which are maybe more, as I mentioned, a bit more difficult to be compatible with AI-generated inventions, in terms of prospect theory or reward theory, if we think about the goal of the patent system as, for example, set out in the US Constitution, so the progress of science, rewarding inventors. What I think it's relevant from a societal perspective is the fact that incentives should be there in order to make sure that innovation continues, and in order to make sure that there is the final goal of the patent system is achieved. Now, considering the fact that there might be changes in market dynamics because AI cuts the costs and because AI cuts the time, so it might create distortions in the market. But again, I see this as something more related to competition law rather than to patent law. I hope this answers your questions.
No, it does. Thank you very much. I'm satisfied.
Thank you. The opposition will be continued by Professor Manuel de Santos Real. Professor de Santos Real is a professor of private international law at the University of Alicante and also a member of the assessment committee.
Thank you, Mr. Chair. Morning, Ms. Candidate. At least half of the torture is passed already, so we come to the second part. You know, since 2017, I've tried to read everything which have arrived to me on the patentability of artificial intelligence, and I have to recognize publicly that I've read a lot, but I have never read a paper where the dogmatic was heavily involved. And I have appreciated a lot. So your thesis, I would include your thesis within the concept of what is a juris dogmatica, yeah? Or a juris magister. Yeah? And I believe that this is the most valuable asset of your thesis. Conclusions is another thing. Well, conclusions are fine. I find them a little bit conservative, let's say, but that's a doctoral thesis, I understand it. But we are here to challenge you. So let me challenge you, dig in a little bit on what Professor Dimitar approached it, just from the perspective of the concept of inventorship. Yeah? You know, if I understood well, you started in 2017, but you put, let's say, you put your research to an end around 1 year ago. Is this true?
Sorry, can you say?
Yeah, you put the thesis was finished, let's say, around 1 year ago.
Yes.
Yeah, that's understandable because of the schedules and so on of the university. Well, you know, on the one hand, artificial intelligence looks very different in 2017 than today, and certainly you are right there. But but 1 year is an eternity on artificial intelligence. So I'd like to ask you whether you would have come to exactly the same conclusions today, after 1 year. How do you evaluate the arrival of ChatGPT on this matter? And when I say that your conclusions were quite conservative, what I mean is that you have done a beautiful lege data exercise, let's say, with the concept of ingenious machine 1.0 and 2.0. But what if ingenious machine is 3.0, where, let's say, where the attribution of inventorship to a human is completely residual or completely conjunctural? Taking into account that in the 19th century, you said 19th century, you have repeated the whole intellectual property system was addressed to humans and not to artificial intelligence. No, was addressed to humans and not to legal entities. Artificial intelligence is not a legal entity, it's something different. So could you tell us just how would you have approached the matter if you would be still until yesterday evening with the possibility of adding something else? Could you imagine a kind of ingenious machine 3.0 and try to go a little bit further? I'm very interested in this because you are the expert. Yeah.
Dear highly esteemed opponent, thank you for your question. I believe that last year, when I finished the thesis, the situation about AI, the conversation about AI was already quite lively compared to when I started the PhD. It is true that ChatGPT was not on everyday news as it is today, but it's also true that the type of artificial intelligence that I looked at in my thesis, that I find it relevant for inventive activities, is not exactly the type of AI that is ChatGPT 3, although I'm aware that this creates other sort of problems potentially. So I would say that it's what I was interested in during the PhD was all the type of machine learning and supervised and unsupervised learning that can direct activities, for example, within the lab, because the case study was on pharma, right? So that's why I focused a lot on that, and then I came up with conservative conclusions for reasons of also data, because the data that I have concerning the functioning of the patent system from an economic perspective as well are quite florid, and also I found proofs that the system was able to adapt in the past, whereas like wanting to think about a different system of incentives, for example, because of an ingenious machine 3.0 would require some evidence that I don't have. And I believe that I would require some information regarding different industrial sectors, because the patent is technologically neutral. So my perspective on the patent system on the pharma sector is very sectorial, whereas wanting to think about something different that might be needed because technology goes on and maybe the system doesn't work anymore. In the case of ingenious machine 3.0, I think this would require some knowledge on how to move the bricks appropriately. So I think that would be needed to think about an alternative.
Very interesting. If I may, are you suggesting that your thesis is limited to a specific sector, which is perfectly fine, yeah? And as a result, that one fits all does not fit at all in this matter? And then if you have moved to another sector, the conclusions could be different, for instance, something which could be very healthy?
I think that could be an answer. I could say that my thesis is, in general, analyzing from a theoretical perspective the requirements, And also from the case study, I analyzed the pharmaceutical sector, but my knowledge concerning the functioning of different sectors and the intersections between patent law and competition law, I think this would be crucial if someone would want to consider other alternatives in the case of new technological paradigms. That's why I would say, yes, I would say it's as a limitation. This is definitely a limitation of the thesis.
Thank you. The opposition will be continued by Dr. Anke Moerland. Dr. Moerland is an associate professor of intellectual property law at the Faculty of Law of Maastricht University.
Thank you very much, Prorector. Dear candidate, dear Francesca, it's my pleasure to be here today and to see you in front of us presenting the results of your PhD project under the broader umbrella of the IPIN Innovation Society project, which I was lucky to be part of. In your research, you have assessed the patentability of AI-generated inventions, and in particular regarding the specific criteria that patent law sets out. I think also today you have presented clearly what that legal analysis entailed and which conclusions you have reached regarding the different aspects of patentability. What I'm still wondering about, and that relates very well to the comment that was just made by my colleague, is the role of your case study on the pharmaceutical sector. You have now already briefly add some information, but I have this doubt because actually none of your research questions is directed to the pharmaceutical sector in particular. And also today, what you presented as your conclusions, I didn't see any of your conclusions specifically addressing the norms or values of that sector or the specificities. So my doubts are of a methodological nature. Which question did you aim to answer with this case study? And if it is, as you seem to allude on page 17, how your assessment of patentability of AI-generated invention applies in a specific, highly relevant, patent-intensive sector, which is something that you mentioned there about the pharmaceutical sector. Then, of course, the question is how the data from the case study can be used in a meaningful way if you have no data to compare them to from another sector that is less patent-intensive or has fewer AI-generated inventions or alike. So my question is, which value does the case study have in your doctoral thesis? And as also was just put, can we generalize the findings to other sectors, or is it limited to the pharmaceutical sector? Thank you.
Highly esteemed opponent, thank you very much for your question. So the case study of my thesis was designed at the very beginning of the research with the purpose of forming a solid ground that could be used to discuss in practice what was the role of AI in inventive activities in at least one sector. The idea back then was that it was not clear from the state of the art to what extent AI could be used in inventive activities. There was no such research, so maybe there were papers and research on the use of AI in pharma, in drug discovery, in drug repurposing, but there was no such thing as clear design of the extent to which AI can perform some of the inventive activities and the extent to which it is actually able to replace human inventors. So the case study was mainly used to design this, to form a ground and to discuss the extent to which AI could perform some inventive activities. Also, part of the case study was aimed at interviewing people working in pharmaceutical companies that were named as inventors in patent applications and asking them the extent to which their contributions could be was automated with the technologies. So in order to also qualify the contributions and understand what kind of contributions could be already automated and what contributions could not be automated. So this was partly because back then the topic was not really explored yet. So I found it useful to have a ground and to categorize the kind of contributions in order to see what was actually possible to automate and what was not. That is why I created Ingenious Machine 1.0 and 2.0.
Can I just follow up? So it was more of a deductive method, like you started from the pharmaceutical sector to inform your exploration and then develop the framework you have done, or did you first analyze the patent law and then looked at how it applies and how you need to see the effect of the law in a certain sector?
I would say more the first one because it went in a parallel. So for the study of the patent law and the research on patent law happened in parallel with the creation of the design of the study. And then I was able to compare what I had on inventorship from the literature with what actually I had from the data, from the empirical data from the inventors.
Thank you.
Thank you. The opposition will be continued by Dr. Kalpana Tyagi. Dr. Tyagi is an assistant professor in intellectual property law and competition law at the Faculty of Law of Maastricht University.
Thank you. My dear candidate, first of all, thank you very much for that nice presentation and sharing a copy of your book. I congratulate you for that. I bring you to page 163 of your PDF version, which is now page 182 of your hard copy of the book, wherein you suggest that overall patent law does not pose challenges to AI-generated inventions in relation to enabling disclosure, and eventual policy changes on disclosure of upstream innovation might arise from other disciplines such as competition law. Now, you also bring it as one of the key findings which you presented on the slides and discussed afterwards. So I'll first delve into patent law bit, and if time permits, which seems to be on our side, the competition law aspect. So let me draw the patent law perspective first. I would like to draw your kind attention to the EPO Technical Board of Appeal decision dated 12th of May 2020, TO161/18, equivalenter Ortendruck RRC Bedroff, a very spot-on case for the purposes of this research that, to my pleasant surprise, I did not find a mention of in the thesis or the presentation today. So let me share a little bit of background about that. This was a case wherein the Technical Board of Appeal, while accepting examination division's rejection for lack of inventive step under Article 56 EPC, also added a ground for rejection due to lack of sufficient training data under Article 83 EPC. So in this case, the claimed method differed only on grounds of artificial neural network. Now, before developing into this patents and pharma subtlety, my question against this backdrop, my candidate, is whether you may like to reflect on your initial observation and the conclusion that you reached today, and perhaps reconsider whether patent law indeed does not pose challenges, because in this case, there was only one ground, which was disclosure bit. To enabling disclosure, and in light of the plausibility requirement, especially for the patent and pharma debate, both from the perspective of Ingenious Machine 1, which you say is based on empirical data, and more particularly so for Ingenious Machine 2, which based on the presentation is a hypothesis of completely autonomous AI-generated invention, so wherein the black box nature of the algorithms becomes even more evident as referred to in your thesis. Thank you.
Highly esteemed opponent, thank you for your question. May I ask you, because I'm not familiar with the case, whether this rejection is related to a patent application for an artificial intelligence itself?
Indeed. One of the problems with AI inventions is these black box algorithms, right? And one of the key points in this is the claimed method differed from the prior art only by an artificial neural network, the training of which was not disclosed in detail. So it was AI generated. And there's also a second subtlety, which is the lack of plausibility, which I may add to.
Thank you for your question. I'm not sure I understood well if this is a patent concerning artificial intelligence or an inventions generated with artificial intelligence.
AI generated, yes.
AI generated,
Yes.
I see. And the base for rejection was the insufficiency of the training data.
Artificial neural network and the data therein was insufficiently disclosed. And if it may help you, I can read the para verbatim. Claim 1 of the application, Article 83 EPC requires, and this is the decision from the EPO, that the European patent application must disclose the invention in a manner sufficiently clear and complete for it to be carried out by a person skilled in the art. To this end, the disclosure in the application fails to enable the person to reproduce the technical teaching because it's a black box, and this must be inherent in the claimed invention on the basis of his general specialist knowledge.
I see. Thank you very much. I feel like I'm not sure I understood everything correctly, but if the problem was the replicability of the invention, the lack of sufficiency of disclosure because it didn't allow the replicability of the invention, then it's something that I briefly explored in the chapter, in the section, as something that could actually be a problem, and this is what I was considering as a problem in terms of not disclosing upstream innovation. This is what I meant, not disclosing the training data or the algorithm used to produce the invention, but only the downstream innovation, so the final product. I was not familiar with this case because I thought this has not happened yet. And I thought this was something that might concern competition law because I didn't know this could actually affect the final product, the ability of the skilled person to reproduce the invention in the description of the claims. But then if this is the case, I should, of course, familiarize with the case and consider it. Thank you.
Thank you.
Thank you. The opposition will be continued by Dr. Enrico Bonadio for a second question.
Yes, thank you. Sorry. I saw, Francesca, that you mentioned the Australia case, right, in your thesis. Probably when you submitted the thesis, the appeal decision was just out. I think you didn't expand on that because probably you did not have time, I guess, because it was during the. But perhaps now you can expand on the reason why you think there has been a reversal there, because we know that in the first instance ruling, this object clause in the Constitution, in the Patent Act, was stressed by the first decision. So, what happened with the reversal?
Dear opponent, highly esteemed opponent, thank you for your question. So in the Australian case, in the first instance, the patent was accepted, actually, and the reasoning of the court was based on motivations that were more in line with the utilitarian approach, whereas with the second decision, with the appeal, they aligned with the UK court, and the decisions of the, although they stated that they are not aligning with the court for the purpose of aligning, but the motivations were similarly based on personhood arguments, interpreting the law, interpreting the concept of inventor through other provisions, not only in patent law, but in commercial law, in private law in general, deducting it from ownership of rights. And so the let's say the argument of the court, both in Australia and in the UK, it's based on the fact that the interpretation of the concept of inventor from a personhood perspective, does not allow for AI inventors.
And do you agree on that? I mean, do you prefer the first instance decision or the second?
I found
What is
that there were good reasons to accept it in the first instance, I must say. I think that the motivations used in the sentence were utilitarian-based, which is actually in line with the patent law spirit. But at the same time, I understand that this is also a matter of quite relevant decision. It will be a precedent for that will influence behaviors from firms as well. So one of these court's decisions also mentioned that this should not be a matter decided by the court, but should be decided in the parliament. So that's I also feel like there is sort of conservative approach, not willing to decide it in the court, but willing to leave it. So
that reminds me of what happened also in UK in the case in the UK where the judge said that again the parliament should be involved, right? So basically, do you agree on this, that case law should not be dealing with this, but the ball should be passed to the lawmakers, the policy maker?
Well, I come from a civil law jurisdiction, so probably I agree. But well, I think that also it's very interesting that the German decision was more innovative in a way, even though it's still a civil law decision, a civil law country. They accepted co-inventorship, naming AI not as the sole inventor, but AI as co-inventor. So that was quite innovative compared to the stances of the UK or the US, for example. That was interesting.
Thank you. I'm satisfied.
Thank you.
Thank you.
The opposition will be continued by Professor Kamperman-Sanders.
Thank you very much, Mr. Prorector. I would like to ask a question about your proposition number 5, which deals with the need for monitoring the level of diffusion of AI data in the public domain. And you then say this should allow to evaluate the need for adjustments in relation to inventive step. In that sense, we are of course also talking about the person skilled in the art and how this person skilled in the art should read inventive step. But what exactly do you then mean, adjustments in relation to inventive step? Does that mean that there should be an obligation on applicants to indicate that AI has been used, so your co-inventorship model? Because that may mean that you apply a different inventive step criterion in relation to such claimed inventions as compared to purely human efforts. And if that is the case, doesn't it also mean that your justification system, which you in any way say should not be very dogmatic but should be practical, ought to be adjusted in that light as well? I look forward to hearing your reply.
And highly esteemed opponent, thank you for your question. I believe that the purpose of the proposition number 5 is based on the fact that I tried to maintain the propositions and the conclusions of my thesis. I tried to maintain it in a conservative way, as Professor De Santis pointed out before. Because I believe that after my research, I believe that the system...
With all due respect, but we ask you to be a bit more proactive rather than conservative.
Yes, I mentioned that this could be a good solution to maintain the situation as it is, unless the diffusion of AI and data makes everything obvious. So that's what is being described by Ryan Abbott in the paper, and this is what would be necessary to consider.
You may briefly finish your answer.
Thank you, highly esteemed rector. So the idea would be to maintain the situation as it is, unless everything becomes obvious, and in that case, the need to adjustment to inventive step would be necessary for the purpose of maintaining an achievable bar for patentability, because otherwise it would be impossible to maintain the system as it is. So that's why I think this is secondary, though. That's why I suggested first to monitor the situation and then eventually consider how to change the requirement depending on the societal needs. I hope this answers your questions.
Thank you. Francesca Mazzi, the time appointed for defending your thesis has passed. The degree committee will now withdraw to discuss the quality of your thesis and your defense. I request that you and your company await the results of our deliberations and our return in this room.
The PhD defense has now ended. The degree committee will debate the candidate's performance behind closed doors. This process usually takes about 10 minutes.
Long road to the south side. 7 miles in my rearview mirror, I know what it felt like. My goal's only getting clearer, east side to the west side. No place like home, if it's questions that you've got, go the extra mile and die. On the line, I know you know that I can't read your mind. Years can't fly by now, don't waste all your time. Cause I'll go the extra mile. Long road to the south side, 7 miles in my rearview mirror, I know what it felt like. My goal's only getting clearer, east side to the west side. No place like home, if it's questions that you've got, go the extra mile and die. On the dash, got my laces tied. Long road, I don't waste no time. Break rules because fate decides. With the team and we chase the light. I make a move, fall down, shake it off. I hate to lose, bad branch, break it off. No room for negativity, praise and love. Prepare for deep part cause we're taking off. Take the mileage, traveling so far from home. Gathering knowledge, other connections. I put the time in to get everything I ever hoped for. It's a challenge and we all in. It's a better future that we go for. And even though these nights seem long, I know that I am never on my own. Know you won the battle once you've grown. South side, 10 miles in my rearview mirror, I know what it felt like. My goal's only getting clearer, east side to the west side. No place like home, if it's questions that you've got, go the extra mile and die. Long road to the south side, 10 miles in my rearview mirror, I know what it felt like. My goal's only getting clearer, east side to the west side. No place like home, if it's questions that you've got, go the extra mile and die. Years can't fly by now, don't waste all your time. Cause I'll go the extra mile.
Manchester from lecturer in IP, which is good because it's good, and another one in France, but then it was not a good moment. So now I have to find some, because I wanted to go back to Italy, and turns out it's a disaster. Let's go here.
Francesca Mazzi, the degree committee here present has assessed the quality of your thesis and your defense. In view of its positive verdict and taking into account your previous qualifications, the degree committee has decided to grant you the degree of doctor. Professor van Engelen is authorized to confer upon you this academic distinction in accordance with Dutch university custom. I invite your supervisor to take the floor now.
Please all rise.
Francesca, do you promise to work in accordance with the principles of scientific integrity at all times, to be careful and honest, transparent, independent, and responsible?
Yes, I promise.
Thank you. By the authority vested in us by law and in conformity with the decision of the committee here present, I hereby confer upon you, Francesca Mazzi, the degree of doctor and grant you all rights attached by custom and law. As evidence of this, I now present you with the degree certified by the certificate signed by the rector, the secretary, and the other members of the committee, and affixed with the official seal of the university.
Please be seated.
The floor is now for Professor Shemtov, for your laudatio.
Okay, good afternoon. They asked me to say a few words, and it brought me back to the way it all started, and it has been quite a journey. Now, I remember when Francesca came to inquire with me for the first time about this unique program and the opportunity it entailed. And these were early days when scholars just started to look at the impact of that advancement in AI technology may have on patent law. Francesca has been an exemplary PhD candidate. She was diligent, clever, and insightful, and on top of this, considerate and respectful. I could not have wished for a better one. Like most journeys, and perhaps more than most, this journey too had its difficulties. Except for the academic challenges of working towards a fast-moving target in relation to a constantly changing technology, we also had COVID-19 in the middle. And on top of this, Francesca held a postdoc position in Oxford University for the last 2 years of a PhD. In other words, there was a lot for her to take in, while at the same time continuing diligently to work on her PhD. She successfully completed the PhD at Queen Mary and passed her Viva without corrections. And I am delighted that she has done the same here at the University of Maastricht, although I expected nothing less. She has done fantastic work, and to all of us who are active in this area, I propose that to watch this space. I'm sure that we will hear of her in the future. Well done, Francesca.
Thank you.
Dear Dr. Mazzi, also on behalf of Maastricht University, I congratulate you with the degree you have acquired, and I would like to extend also my congratulations to your parents, your family members, and your friends, and also those who are attending this session online. After concluding the session, we will proceed to the stairs in the central hall, where we will take a picture of the group, and then afterwards there is a reception in another wing of the building. I hereby conclude this academic ceremony. Thank you.
Thank you.